Shri Arun Jaitley.
Madam, I beg to move that the Election and Other Related Laws Amendment Bill 2003 be taken into consideration and approved by this Honourable House. Madam, I may mention at the outset that this bill has already been approved by the Lok Sabha. It had also received a stamp of approval after extensive consultation by the Standing Committee. And the object of this bill is to cleanse the process of political funding in India. Madam, it's a matter of concern for all of us that even 56 years after our independence and 53 years after we put the constitution which formulated and provided for a parliamentary democracy in India, we have not been able to develop a legitimate mechanism of political funding in India. Politics is an essential part of our life. Parliamentary democracy regulates our political system. Political parties are an essential component of that parliamentary democracy. How are political parties going to be funded? It may not be entirely untrue if we are to even make a confession that there is a popular perception that it is money in the unfortunate color which is perceived as black money which is used to fund the political process. Do we allow this process to go on, or do we allow this entire process to be corrected? This bill is an humble beginning, madam, a first step attempting to cleanse that entire process. The provisions of this bill broadly are in the category that political parties which have always been entitled to receive money from individuals, from partnership firms, from HUS, from companies other than government companies by check. But in the absence of a proper system, these check monies have not been coming primarily to the political parties. Government companies are not entitled to donate any money under this bill. And as far as companies are concerned, there is another restraint upon them under Section 273 of the Companies Act, that whereas monies of individuals or partnership firms or HUFs is individual money, there is no upper cap on donation. Corporate money is also shareholders' money, and therefore there is an upper cap in the Companies Act that at best 5% of the profits can be given as a donation to the political process. This bill takes a major step forward in as much as it incentivizes donations and payment of money to political parties by check, that whatever monies are given to political parties by check, subject to the limitations that exist in the Companies Act, as far as companies are concerned, with no limitations as far as other assessees are concerned, there would be an adequate tax incentive in as much as this money would be admissible as a permissible deduction for the purposes of income tax. So henceforth, for any person to siphon money out of business and then donate it for the political process itself may not be an incentive enough. There will be an incentive if he is to give it by check, and this is the first step that this bill takes forward in order to incentivize these payments by check. I may mention at this stage that the Congress party had appointed an inner party committee headed by Dr. Manmohan Singh, which had made several recommendations, and a large number of those recommendations have also been taken into consideration by us while formulating this particular bill. We have also a prohibition in this act which continues that no foreign company which is prohibited under the Foreign Contributions Regulation Act from making any donation can make any donation to a political party. That embargo itself continues. There are several other changes which we have made, particularly in the view of the report of the committee headed by the late Shri Indrajit Gupta on the process of political funding and the funding of the election process. The committee had made twofold suggestions. The first formulation of the suggestions was that there must be public funding or state funding of the electoral process. The second part of the recommendations left it to the government to come out with a proper system by which political parties could accept donations. That part we have tried to legitimize by this bill. But as far as the first part is concerned, we wrote to the state governments, because the formulation of the Indrajit Gupta committee report was that a corpus of about 1400 crore rupees would have to be created. 700 crores would be contributed by the center and 700 by the various states. When we wrote to the various state governments, most of the state governments, I did not go into the details of which one, expressed their reluctance to make any contribution in the matter in view of their own fragile fiscal conditions. We have therefore provided in this bill, taken some aspects of that report with regard to equitable time sharing as far as the public broadcasting channel is concerned, the Doordarshan and the Prasar Bharati channels. We have also provided that on private channels, including cable channels, there would be an equitable allocation of political time during elections, which would be regulated by the Election Commission. We have continued with the present dispensation of electoral rolls being made available to candidates of political parties free of cost. And depending upon our ability to raise further revenue, we have also had an enabling provision in this law that in case the situation in that regard improves, the government may from time to time notify such other amenities which could be given to candidates at the election time, so that the expenditure of the individual candidates themselves or their reliance on other donations itself comes down. Madam, this bill was referred to the Standing Committee. The Standing Committee headed by Shri Pranab Mukherjee has put its stamp of approval with several suggestions and comments which they have made in this. And since there was a larger consensus amongst the political process that there is a need to cleanse it, because this cleansing directly impacts upon the credibility and legitimacy of Indian politics and political parties, I commend to this House that this bill be discussed and approved by this House.